So how does an offer terminate? Well, a rejection will terminate an offer. A rejection always terminates an offer. If I offer to sell you my computer for $500 and you say, no, I'm not interested, that offer is terminated. If you call me up 15 minutes later and says, I changed my mind, I would like to buy your computer, I'm under no obligation to do that. What you have done is now terminated the offer that was outstanding, and now you've made your own offer of an offer to pay for a computer. So a rejection will terminate an offer, even a firm offer. So even if there has been an irrevocable offer out there, if I say I'll sell you this, I'll give you 48 hours to think about it, and you tell me no in the next 6 hours, and then change your mind after 24 hours, it's too late. The offer terminated upon rejection. So when that rejection reaches the offeror, the offer is terminated. It's no longer valid. So on your test, how will it come up? Well, if someone rejects an offer, then there is nothing left for the offeree to accept. The offer is gone. Acceptance. All right, so now we have an offer. It has serious intent. It has not been withdrawn. The question is, how do we accept the offer? How do we accept the offer? Under the CISG, acceptance can be made either expressly through communication. I accept your offer. Or it can also be conduct, anything that would indicate that the offer is an acceptance. So if we have a situation, for instance, where in which I offer to purchase 500 widgets from you, and you never formally accept it, but you ship me 500 widgets, that's enough to indicate that there is an acceptance of the offer. Now, there's really two elements to acceptance, and the first is assent to the offer. You've agreed to the offer. So assent is something that would indicate assent, whether it's your express comment or the conduct. And then communication of that assent to the offeror. The law states that an acceptance is not effective until the acceptance reaches the offeror. Once the assent of the offeree reaches the offeror, the contract is formed. When the assent, notice of the assent, reaches the offeror, the contract is in place. Contract is a valid, enforceable contract at that point. And again, no need for consideration. Mutual assent. When is acceptance effective? Well, this is something that we talk a lot about in 3213, and having to do with what's called the mailbox rule. And in the common law system, and then for common law contracts in the United States, acceptance is effective as soon as you put the acceptance into the mailbox. As soon as you transmit the acceptance, it is effective for purposes of the law. The contract is formed at that moment. The CISG is slightly different. According to the CISG Article 18, an acceptance is not effective on dispatch, but is effective when it reaches the offeror. As we were saying before, when notification of the acceptance reaches the offeror, under the CISG, that's when the contract is formed. Under the common law, the contract is formed when there is transmission, dispatch of the assent. So this means that an offeror may have additional time to withdraw an offer because acceptance is not going to be valid until it reaches the offeror. So this means that an offeror may have additional time in which it may withdraw or revoke the offer. Under the CISG, the acceptance is not valid until it reaches the offeror. Battle of the forms. This is something that comes up now that we've talked about mutual assent. The problem is that oftentimes companies are not using express forms that indicate offer and acceptance, that oftentimes they'll use pre-printed forms or electronic templates in which there is a variance between the offer and the acceptance. So how do we know when there is mutual assent if there is this variance between the offer and the acceptance? Now, under the common law, we follow what's called the mirror image rule. And the mirror image rule says that acceptance must exactly mirror the offer. If acceptance does not exactly state what the offer was, then it acts as a termination of the offer and a counteroffer. It's a rejection of the original offer and the creation of a new offer, the counteroffer. A contract does not exist if there is a variance between what the two parties have submitted. So if in making an offer I send in a purchase order and the other party sends me back a confirmation and those things don't match up, under the common law that means there's no contract. There's not a contract there. Now under the UCC takes a much broader approach, and under the UCC a written confirmation that is sent within a reasonable period of time will confirm the new offer. There's much more latitude as to the formation of a contract because the UCC recognizes that merchants dealing with one another may be using their own pre-printed forms, and it can be problematic if two parties act as if there's a contract and in fact there's no contract. So if there is no objection to the changed terms of the acceptance under the UCC, they become part of the contract. Under the CISG, Article 19, on its face it sounds exactly like the common law rule that says that the acceptance must mirror the offer. It must not contain any sort of additions or limitations or other modifications. Otherwise, it's a rejection of the offer and it constitutes a counteroffer. That's the rule. However, the rule is qualified by providing that alterations or additions must materially alter the terms of the offer to constitute a rejection. So if the changed terms do not materially alter the offer, they may become part of the contract. How do we know what material terms are? Generally speaking, material terms relate to price. If there's a variance in the price between the offer and the acceptance, no contract. Payment, how are payment terms going to be made? The quality of the good, the quantity of the good, the delivery terms of the good, those are all involved, those are all material terms. If there's any variation on any of those terms, then there is no contract. And finally, the last one, dispute settlement. We know that courts will recognize the rights of the parties to agree on how they will resolve disputes. If there's a variance in the dispute resolution set forth in the offer and in the acceptance, then that's a material term. That's a material alteration, and no contract is formed. Hypothetically, a German seller sends an offer on a pre-printed form to an American buyer. The American buyer then uses its own order form that contains a standard clause that says that disputes are subject to the jurisdiction of the United States, can only be heard in United States courts. The seller doesn't respond and no goods are shipped. Well, if the American buyer then sues the German seller, there's no contract. No contract has been made because the buyer's order was in fact a counteroffer. It was not an acceptance that it purported to be, but instead was a counteroffer. A material term having to do with dispute resolution was changed. I'm going to post a separate lecture on the types of forms that are used. I'm going to show you what they actually look like, pre-printed forms that are commonly used. And so make sure you watch that. That'll give you some greater knowledge of what we're talking about in this part of the course. And that's it. So in conclusion, what do we learn? We've learned the general requirements for a valid contract, mutual assent. We've learned contract formation issues can arise, and we know now about offer and acceptance according to the CISG. And that's it. Thanks. This is it.